It's showtime. Welcome to another live. I am your host, Dave, a 10-year intellectual property attorney dealing with everything from patents, trademarks, copyrights, and trade secrets. And hey, we got a good show for you guys today. We're talking about a little bit of everything. I actually switched up the lawsuit breakdown. It was initially going to be on the Scooby-Doo lawsuit. Scooby-Doo, or the owner of the Scooby-Doo trademark, ended up suing a cleaning company called Scrubby-Doo for trademark infringement. But I switched that out for your boy 50 Cent, his kind of trademark copyright lawsuit that he has. So we'll be talking about that instead. Obviously, we're going to talk about Shedeur Sanders sliding to the fifth round, and kind of I'm going to give you guys my take on the IP front of that. Sinners, your boy Ryan Coogler, a big payday, big box office success with the movie Sinners. I heard it was a great movie. I haven't seen it yet. We're going to be getting all into that, as well as what else do we have? Fox. It seems like Nike has scored a win in their kind of trademark battle against a influencer. I think YouTube, TikTok, an influencer for a trademark infringement. So we get off a little bit into that. But man, I titled this, and I'm tired than a big dog. I'm extremely tired, so I'm not going to hold you guys up today. But we are going to get through these things, and this actually is going to be a very important stream for you guys. I titled this "Deeper Than a Brand," and this kind of a play on words. Number one, obviously, we know trademark, all this intellectual property. This is a part of branding. So, and I'm saying this deeper than a brand. The Shedeur Sanders, that kind of slide kind of made me come up with that title and really kind of talk to you guys a bit about deeper than a brand. And what I mean when I say deeper than a brand, it's really about having a freedom to do what you want to do in control. And again, on this channel, everything intellectual property, having IP, whether it's trademarks, copyrights, patents, trade secrets, having a business, kind of doing what you do. It gives you that flexibility as well as, or the freedom, as well as it gives you that control. When I woke up this morning and you see the pink wristband on, I woke up this morning. I went to the gym, worked out, and then right after the gym, I told myself, man, I want to go to the Pistons game. So this is like club access wristband for the Pistons game. And we had a phenomenal time. Now, they did not come out with the win versus New York, but just kind of being able to kind of drop $700 and that not really affect me on the club access seats, and then kind of come to you guys and kind of do this live show afterwards. Again, I have that kind of freedom and that control to be able to do that. Now, I'm not saying I'm wealthy by any means, not at least yet. However, kind of we all aspire to have that control and that freedom to be able to do things that we want to do. Hence the name of this, Deeper Than a Brand. So the brand, the trademarks, the business, all that is important. And this is what I'm teaching on my channel. However, the real reason why I'm kind of teaching intellectual property and be able to kind of own your business and kind of own your IP is so that you have flexibility and control. And with all that said, I think I want to jump right off into the show with your boy, Shedeur Sanders. Now, again, Shedeur Sanders, he was a projected initially top 2 pick, and then it slid to maybe a top 9 pick. Then it slid to the first round, top 21st pick, and then he ended up going to Cleveland Browns, I think, at 144 pick in the 5th round. And again, I titled this Legendary because your boy Marcellus Wiley, and I'm going to play this clip here in a second, he kind of was talking on his show a couple of days ago how the NFL, I mean, he kind of made some comments that I didn't necessarily like about how Shedeur Sanders having this kind of legendary kind of theme room turned the NFL off, as well as some brand owners. So I'm going to kind of play that here really quickly, and then I'm kind of give you guys my thoughts on that whole saga here. So let's go. Let's kind of play this. Let me make sure it's on the right. Okay, let's see here. Yep, it's on play speed. Let's check this out. Let's go. And please leave a comment, man. I want to make this an interactive approach. If you guys have any questions, definitely please leave them in the comment section. Again, man, I'm almost $400 an hour, and you guys get a chance to ask an IP attorney these questions for free. So don't be afraid to ask your questions, and definitely leave a comments on what you think about these different topics in the comment section. I'll definitely do my best to answer them. Let's go.
And that's the problem. Let's start there. Okay, so if you're an evaluator, you already know he's coming in. You got some average attributes, some exceptional attributes, but all in all, not the highest graded quarterback this year, but somebody you should draft, right? And imagine if you're a team and you're thinking, where should I pick this guy, as you're trying to hire a new prospect who is nothing but an employee, but a highly paid employee. And if he's not going to be your top dog, then it's like, okay, I need somebody who's going to be coachable, who's going to come in here and buy in. And then you click on the TV screen as everybody else is. You're in the war room and you see a prospect that has legendary built into his house, built into his rooms. He hasn't taken a snap yet. Then it makes you start to think, and this is not right, but this is the way it goes. You start to think, legendary, you ain't even did jack. Oh, the same dude that had a beef with an NFL MVP in the name of Cam Newton. Cocky reports. A lot of anonymous coaches and sources saying, I don't want a guy that's going to be giving out more press conferences than he's getting game reps. It's a little noisy back there. Our backups are noisy. Telling you how the game goes because the NFL is militaristic. It is a military outfit. It is. And they will discipline you if they can. Unless you're elite and you got the hammer, if they got the hammer, trust me, they're going to always swing it. So
I think shout out to Marcellus Wiley. That's all I want to play of him. I do actually want to pull up what he was talking about with Shedeur Sanders' custom draft room with the legendary. So let's kind of play that here really quickly. Then I kind of give you guys my thoughts on this whole kind of legendary saga. Let me see if I can do this here really quickly. Okay, let's go. This Shedeur Sanders draft room for the NFL draft. See the legendary there. See the couch, legendary pillows, legendary all in the back. So that was pretty straightforward here. And I guess what I want to say about this is because it's almost like a two-sided thing. And Colin Cowherd, which I actually like Colin Cowherd takes, but I couldn't disagree with him more, similar to what Marcellus Wiley said as far as, hey, you see this legendary stuff everywhere, and that kind of turned teams off. Man, again, I think that's lazy journalism, which I said on that breakdown live, because if anybody who's been following Shedeur Sanders for any amount of time, this whole legendary is part of kind of, his thing, his brand. He's been kind of rocking this legendary brand for years now. And on one end, we always say, hey, manifest what you want to do, manifest what you want to be. And then when this gentleman is manifesting, not only manifesting it, but he's branding himself as being legendary. He actually even filed some trademarks for the word "to legendary" as well as the logo. So when he's kind of branding himself with this kind of legendary status, now people has a problem with it. The NFL draft has a problem with it. Pundits have a problem with it. And I just don't like it. And I think in the age of NIL, more athletes, this is why it's important for you to brand yourself, for you to own your intellectual property, because in my opinion, this is the NFL way of saying, hey, the Sanders brand, your legendary brand, Shedeur Sanders, is not bigger than the NFL brand. And this is what they did as a result of trying to kind of dim that light. And if you think that all of a sudden Shedeur Sanders, which I said on my full breakdown, if you think that he dropped to the 5th round because of some bad draft interviews or because he had the legendary status, I have a lake in Las Vegas to sell you. This is essentially, I'm not going to say blackball, and we'll never know the real reasons. Maybe it comes out one day, maybe it doesn't. But this is essentially the NFL way, and I'm not talking about the front office, the owners. This is their way of saying, hey, you're coming into our world. You don't own anything. You need us. And as a result of that, we are going to essentially, try to humble you. I don't even think this was about race. This was a specific situation for the Sanders brand, as well as Shedeur Sanders and his legendary brand. And I think it's unfortunate, but this is kind of new way of doing things with the NIL. And I think more student athletes, which they are doing, branding themselves in college. Just think of Beast Mode, which we all know what Beast Mode did in NFL. Just think if he had Beast Mode in college. He had the brand. He had the apparel. He would have made a ton of money back in college, in addition to the NFL. Now, obviously, the brand is only as good as you are, the quality of the person, the product, in this case, Shedeur Sanders. So, again, he was great in college, and that's why that legendary brand became such a big thing. Now, if he can continue that in college, in the NFL, it's going to continue to be big. So, at the end of the day, what I want to say, and this is the whole, like I said, it's deeper than a brand, because, again, it is really about kind of freedom and then control really to the average people. But, again, at the end of the day, people are going to try to, it's all about leverage. And I think Shedeur Sanders having this kind of, obviously he's a good football player, and to the extent that he continues to kill in the NFL level, that legendary brand and this draft day stuff is going to is going to be kind of washed down. That legendary brand is going to be bigger than ever. Because ultimately, the way the thing I love about being in a capitalistic society, the market is going to decide. The people is going to decide whether or not the product is good or whether or not the product is bad. And to the extent that the product is good, they're going to eat it up. And if the product is bad, they're not going to eat it up. So this whole legendary thing, this brand, shouts out to Shedeur Sanders for having a brand and then for protecting the IP, the trademarks for the brand. And to the extent that he kills in the NFL, that brand is going to be bigger than ever. But hey, don't let anybody kind of dim your guys' light until your brand, and regardless of whether it's the NFL or whatever the case may be, continue to do your thing and kind of go from there. So with that being said, I'm gonna move on to Build-A-Bay. This was our interview of the week, and actually, let me kind of tee it up here. Her name is Brittany Rowe. This was a cool interview because not only is she from the great state of Michigan, I think she grew up 30 minutes from where I grew up at, but she's also, kind of pull it up here. I don't like that, man. Oh, here we go. Mastering IP. Not only is she from the great state of Michigan, she grew up 30 minutes from where I grew up in Muskegon. She grew up in Grand Rapids, but she kind of currently now resides in New Jersey. She also went to my alma mater. You see the jersey in the background, Michigan State. She went to Michigan State University, where she majored in theater and whatnot. And again, much like a lot of people during that pandemic, that COVID time, hey, things got a little rocky, got a little shaky. She maybe wasn't working a lot, which she talked about in the full interview. Go check that out. But again, her and her brother and her brother's fiance came up with this card game called Hella Awkward. The Build-A-Bay is an extension of that card game, is the next evolution of that card game. So, and I actually kind of purchased it. So we're going to take a look at kind of what she has to say about the card game, what she has to say about her product, and then I'm kind of give you guys my thoughts and kind of share some more information about Brittany. Let's go.
Being a solopreneur would be a whole other beast. And I feel for those of you out there who are solopreneurs, that is so challenging. I mean, this is already hard in itself, and that has to be so challenging to do it solo. But I feel very grateful. I have my brother and I have his partner, Jane. So my background, like we said, is in theater. So for me, it's all about the storytelling, the connection, the helping people build relationships. I've done a lot of work in social media because of those things. I'm comfortable being the face. I also happen to be type A, so I'm very organized and can make sure all the tasks get done and keep everything moving and going. And then my brother, his background is actually in business and in sports marketing. So he was able to do a lot of the initial, the IP, making sure we have our IP together, making sure our LLC is formed correctly, making sure we get a decent lawyer that we can afford, and, doing all of the business formation things that, I didn't know when we were first starting. And then Jane, she's a product designer. So she is the one who actually puts together the design and can do all the sketching and put together, the functionality of how the game can work. And so all of those things are super important, and I'm not a designer, I don't have a business background, but I have people who do. And so when we have really defined roles, it makes everything flow easier.
And so I guess on that particular clip, she was talking about the importance of really having a team, and how, a lot of times if you're going into business, whether you have a product or you have a service, you're trying to do everything on your own. She talked about the product design and the marketing and kind of the organization, the operation side of things. If you're trying to do all that on your own, it can be overwhelming and things can kind of slip by the wayside, and it can really affect the business. So she was just talking about how the fact that her sister-in-law, or essentially the brother's fiance, is a product designer. So, she kind of dealt with the designing of the cards. Brittany, she's the CEO and she's more of the face of the brand and kind of organizing and operation things, which is kind of what she's great at. And then the brother is on the business side. I think he has a background in business, so he's kind of getting everything from a business standpoint taken care of. And again, it works for them. And I think more people, as they are starting a business, really should try to kind of get with people that they can trust, that complements their skill sets. For example, if you are a technical or engineer, you maybe need to get with a marketing or a branding person, advertising person, to kind of help put out the brand. And again, that's essentially what Brittany was talking about. Shouts out to Brittany. Again, they got a deal on Shark Tank with Robert. Listen to me. They started this company during the pandemic with less than $10,000. So the pandemic was 2020, 2021. So they started this business with less than $10,000. And as of last year in 2024, they've made over $600,000 in revenue for the business. And again, it's a card game, so it's not a ton of overhead, or it's they have great margins to the point where they made money on a business as of last year. So again, anybody can do this stuff. Brittany, shouts out to her for the interview this past week. Go check out that full interview with Brittany, man. She's amazing. With Hella Awkward. It's a card game, Hella Awkward. And I think the next game, which you see here on the screen, Build-A-Bay, I think that Build-A-Bay card game is going to be phenomenal. The flagship card game that she has at Hella Awkward, again, a Shark Tank product, is called Hella Awkward. But this Build-A-Bay that just recently came out, I purchased the Build-A-Bay myself. But that Build-A-Bay card game, I think a lot of people, particularly in the African-American community, I think is going to be able to get with that card game and kind of make something out of it. So let's kind of move on to the next part of the show. And at this point, we're talking about your boy, or let's see here. Make sure I'm getting with the right one, man. Let me see here. Did I have that right? Ryan Coogler, coffee shop announces. Okay, here we go. We are talking about Buc-ee's. Now, y'all, if anybody's been watching me for any extensive period of time, y'all know I've been on Buc-ee's for a while now. And hey, it seems like Buc-ee's have been successful. Now, for those of you who maybe been living under a rock, Buc-ee's is like this giant, essentially gas station. If you go in, they sell, traditional gas station stuff. They sell clothes. Man, it's definitely an experience and a vibe. I was able to kind of try out or experience it for the first time last October, I think in Nashville, Tennessee. And it was a vibe. But lately, Buc-ee's has been on a suing spree to a number of gas stations, particularly in the Ozarks and Missouri. One of those gas stations is Ducky's. Another one is Barcy's. Now, I thought I thought that lawsuit was shaky at best for Buc-ee's. I thought the Barcy's, the logo, I thought was, a little bit more shaky for Buc-ee's, but I think Buc-ee's, the word mark. I thought that, Barcy's found themselves in trouble. But again, it seems like Buc-ee's has won. Buc-ee's has forced, and this is why this IP is so important. Buc-ee's forced Barcy's, a gas station in St. Louis, to close shop altogether. I think they're selling like lemonade now. They closed from the gas station. They're opening up as like a lemonade shop. They have some other like pastries and stuff. But Buc-ee's forced Barcy's to close down. And it seems like Ducky's, they're essentially in talks with settling with Ducky. So it seems like Ducky's has came to the settlement table. Now, I don't know the terms of the settlement, whether or not Ducky's is going to still be able to use the cartoon character or the name Ducky's. However, Buc-ee's has forced Ducky's to come to the settlement table, and it's forced Barcy's to actually close shop altogether. And this is why, number one, it's important to get intellectual property. But to the extent that you're opening up a business, you're using a name, you need to go to an attorney and essentially let them know what you're looking to do, the logo, the business name, and see whether or not you're infringing on someone's trademark by doing that. Because Barcy's, man, they just opened a couple months ago. And all of a sudden, and you would imagine that they've spent a ton of money opening the store, kind of reconfiguring things, coming up with products, things like that. And 2 months later, 3 months later, they have to close shop because they're essentially committing trademark infringement. So they could have saved a ton of money by going to an attorney ahead of time, and that attorney or trademark attorney telling them that, okay, you're likely going to be sued if you use his name, and they could have didn't go into business altogether, or they could have used a different name. So again, the importance of intellectual property, because you can't throw your weight around as Buc-ee's has done. Buc-ee's, again, it sued a number of people. Barcy's, it sued Ducky's, it sued another one, Superfuels, and it forced Barcy's to close shop altogether, and it forced Ducky's to come to the settlement table. So yeah, let me know if you guys in the comments have been to Buc-ee's before. Let me know how you like it. Like I said, I've been to Buc-ee's a couple back in October of 2024. It's definitely a vibe. It's a big deal. It's definitely a big deal. And it seems like they have forced 2 gas stations in the Ozarks, which is Missouri, to close down. So, again, let me know what you guys think about that in the comment section as we move on here. And again, I see we have a couple people join. Hey, please leave your comments, leave your questions in the chat. This is probably the only time this week that you're going to be able to talk to a patent attorney, intellectual property attorney. So again, you might as well get your IP questions answered for the free ball. As we move on here, you see your boy Ryan Coogler. Now, I love this one. So Ryan Coogler, and I haven't seen the movie Sinners. Let me know in the chat if you've seen it. It did numbers in the box office during the opening weekend last week. I think it did over $40 million. I heard it's like a vampire movie. And this week, I'm not sure what it did, but Ryan Coogler, he's the director, the writer of the movie. And it seems like I think Warner Brothers currently owns the film, and he was able to strike a deal with Warner Brothers on the copyright. Now, again, for those of you who don't know, books, TV shows, movies, music, all that is protected via copyright. And it seems like Ryan Coogler was able to get the copyright to negotiate the future ownership of the copyright in a film. So I think 25 years down the line, he gets ownership back from Warner Brothers of the film Sinners, which I think is important for a number of reasons. Number one, you can have Sinners 2. Just think of the Bad Boys movie, for example. How many Bad Boys is it now? It's like 4 Bad Boys. So Bad Boys has been going on, and I think the initial one came out in 95. This copyrights, the importance of copyrights is it has a long shelf life. It lasts for the life of the author, so the life of Ryan Coogler, plus 70 years. So you think of a generational wealth. He's going to be able to pass this film down to his kids and his grandkids. Now his kids or his grandkids or Ryan Coogler 25 years from now, once he get that ownership, he can come out with Sinners 2. He can come out with Sinners 3. He can come out with TV shows. He can derivative works. He can come out with with TV shows. He come out with merchandise apparel for the movie Sinners. So again, it's big that he's able to negotiate the copyrights of the ownership of the copyright of this film, which goes back to him from Warner Brothers 25 years later. And kind of going back to what I said about this whole deeper than a brand, this is big because it seems like the inspiration for this movie, according to Ryan Coogler, was number one, his grandfather, which it seems like he never met, but number two, his uncle. So he doesn't necessarily try to negotiate ownership of the film, but it seems like this one was special to him because of his uncle, because of his grandfather, and therefore he wanted copyright in this one. I think they said Quentin Tarantino and maybe 2 or 3 other producers were able to get copyrights, were able to negotiate copyright ownership in their film at a later date. So yeah, man, he joined the big league. So shout out to Ryan Coogler. Yeah, let me know in the comment section if you guys have seen Sinners. Like I said, it seems like a lot of people are talking about it. And there's one chick, I think she was on one of the co-hosts of the Breakfast Club, said she saw it 3 times. Now I'm not I don't know, man. I watch a lot of sports, and then other than that, I don't typically watch TV. But it seems like a lot of people are loving it. Some people are hating it, but again, it seems like overwhelmingly majority of the people like the film. And again, obviously, it did well in the box office. It's opening weekend with over $40 million in revenue. So again, shout out to Ryan Coogler for the film. As we move on here to the next subject here, and this is Nike. I actually just came across this one today. Look, man, I had a busy day. Like I said, I went to the gym. I went to this Pistons game, and I ended up kind of doing some research. And Nike, it seems like Nike, and we're going to take a quick look at this Bloomberg article. We're actually going to read this one. This just came out a couple of days ago. Nike scores a partial trademark win against influencer over fakes. I do want to kind of say to you guys, man, to the extent that you are an influencer and you are, you have some clout, you have some recognition on your social media profiles. If you think you're going to get away with any type of trademark infringement, copyright infringement, hey, man, these owners are going to come after you, whether it's Nike, whether it's Adidas, whether it's Louis Vuitton, heck, whether it's ABC, whatever the case may be, they're going to come after you. Hence the importance of this intellectual property and actually owning the intellectual property. It seems like Nike kind of slapped this guy on the wrist. Let's go through the article here really quickly. Then we're going to end out with the lawsuit here. So Nike convinced a Florida federal judge that a social media influencer infringed his trademarks by selling counterfeits. Then this guy was selling knockoffs. I got a quick story to tell. So back in my younger days at at Michigan State, and I'm not sure if Brandon is in the chat, but Brandon can attest to it because he called me out on this. And again, this really underscores a bigger point. But if you can't afford the real thing, just either don't get it or try to work hard until you can afford the real thing. I had to be like a teenager at this point, maybe freshman, sophomore year. And I got a hold to this company. They were selling, I'm not sure what number Jordans they were, but they were essentially knockoffs. I think they were like the 12s or something, but they were knockoffs. And a buddy, obviously my chief content creator officer, he pretty much he's a shoe aficionado, so he noticed that they were fake, and man, he gave me hell on those shoes. He used to scrunch them up, and I couldn't do anything because shit, they were fake. But again, me trying to be I don't want to say cool, but me trying to act like I have the real thing going. And again, he had the real thing going. He spotted them instantly, and he used to give me hell about it, scrunch them up, and so I don't know, man. Hey, if this stuff is fake, if you're trying to buy fake shoes, it's not worth it. I'm telling you, it's not worth it. Especially at this age. Now, I see if you can do it as a kid, but if you're like 30, 40 years old, 50 years old, buying knockoff purses and bags and shoes and clothes, I don't get it, man. Not at this point. Maybe as a teenager, I would understand it, but not at this point. Let's continue on with the article nonetheless. Eben, I'm going to call him Fox. Fox, who uses the handle Cadez on social media, failed to provide evidence contradicting Nike's documentation that he sold counterfeit products on Discord and facilitated others sellers' infringement, according to Monday, or the granting Nike partial summary judgment. So essentially, the court partially summary judgment is it ruled in favor of Nike. That's essentially what that means. Nike's remaining trademark claims, including those over videos and website Fox made, will head to trial. So it seems like this one is heading to trial, which is going to be interesting. Fox has over 1 million. That's what I'm saying. My point to you guys earlier. If you got 1 million social media followers and you are selling knockoffs or infringing somebody else's copyright trademarks, they're going to come after you at some point. The big dogs are going to come after you, and it seems like in this case, Nike has came after them. Let's read here. His YouTube video titles included "I returned fake Nike shoes to Nike" and I wore fake Nike mag to SneakerCon. Now this one is actually still up, but I actually checked out his YouTube and I didn't see this first one. I returned Nike shoes, fake shoes to Nike. Now it seemed like Nike sued him back in 2023, alleging he's the ringleader of an organized counterfeit trafficking community based on Discord. And I typically only see the word trafficking thrown around with human trafficking. But if somebody's referring to you as a counterfeit trafficking or trafficker, that's definitely not a good thing by any stretch of the imagination. So it seems like some of Nike's trademark claims were based on websites Fox co-owns, his YouTube and TikTok videos. Nike also alleges Fox partnership with a shipping agent. So it seems like he essentially was in cahoots with some people that helped him ship out the gear. The shoe manufacturer, Nike, moved for summary judgment in December. Fox opposed, arguing Nike's failed to establish likelihood of confusion. So it seemed like, again, this whole likelihood of confusion, which is trademark, the standard for trademark infringement, Fox is pretty much saying, hey, Nike didn't show his burden of proof. Evidence of Fox's Cash App transactions and the authenticity of Nike's goods identified in the transaction descriptions warrant summary judgment. So it seems like, hey, them Cash App, everything is going cashless. The Venmo, I just Venmo somebody some money. Cash App, Venmo, Zelle. Hey, to the extent that you're trying to do something illegally and you're using one of these Cash App services, you're going to be caught. Seems like what they're saying, judgment in Nike's favor. The court denied summary judgment. So it seems like on some other stuff, they're going to court. So again, Nike has won, at least partially, their trademark infringement against a social media influencer who has, across his social media platforms, over 1 million subscribers, or essentially followers, whatever you want to call them. So shouts out to Nike for winning. We're going to end this thing on a good note, talking about your boy. It's 50. I didn't change, actually still didn't change out the what's name for it. Let me see here. Let me see if I can go to it. The window. This is going to be a big one. Okay, here we go. So your boy 50 got sued. So we're going to break down this lawsuit. Look it. Actually, I was supposed to be talking about your boy Scooby-Doo, the owner of the Scooby-Doo trademark suing a cleaning company. But when I saw this 50 Cent lawsuit, I had to switch it out. And I still didn't even get a chance to switch out the overlay. But we're going to go through it here. So 50 Cent has sued Ryan Kavanaugh, Skillhouse Movie LLC, and Gen TV for essentially IP infringement. Let's go through this really quickly. Then we're going to get you guys up out of here. Statement of the case. Now, this is an interesting one. And 50, you may not like me for this. Please don't come at me on social media, though. This action concerns defendants brazen, and this is 50 Cent attorneys talking now, brazen and unauthorized attempts to use the name, image, voice, and trademarks of Curtis Jackson III, a.k.a. 50 Cent. to promote, market, and sell the Defendant's film Skill House. So it seems like all this is based over a film called Skill House, which 50 Cent has some dealings with. Although Jackson had discussions with Kavanaugh about acting in and producing the film, the parties never reached a final agreement. So keep this in mind. Jackson trusted Kavanaugh, who, despite a series of scandals and bankruptcies, is a well-known name in Hollywood, and provided his acting services with the expectation that the parties would come to a negotiate and hopefully reach an agreement. Now, let me kind of put you guys, I need to know your guys' thoughts in the comment section. It seems like 50 Cent acted in this film, was never paid initially, and trusted a guy in Hollywood that they later reach a deal, and this guy has a series of scandals and bankruptcies. And this is why I got to bring 50 Cent to the congregation. 50, you way too smart for this. You're trusting a guy that the negotiations and business is going to be taken out or going to be kind of made right later down the line. And this guy has a series of scandals as well as bankruptcies to his name. You're thinking that you're going to get paid. Come on, man. 50, you way too smart for this, at least in my opinion. Let me know what you guys think in this chat. 50, way too smart for this. You see it here. Jackson trusted Kavanaugh, who, despite a series of scandals and bankruptcies, is a well-known name in Hollywood, and provided his acting services with the expectation that the parties would continue to negotiate and hopefully reach an agreement. So 50 Cent acted in the film and thought he was going to get paid on the back end, and that seemed to fail through. Let's continue on. That trust was misplaced. No final agreement was ever signed. So 50 never ever signed an agreement, although he acted in this film. Nevertheless, the defendants have billed Jackson as a star and a producer of the film. Defendants have shamelessly and deceptively marketed the film as 50 Cent movie and produced by 50 Cent when it has nothing of the sort. They also have a prominent feature Jackson's name, image, and voice, and other identifying characteristics in the film itself in various promotional materials. Despite publicly labeling Jackson as a producer of the film, Jackson was given no creative input into the film. Indeed, defendants counsel claimed that Jackson does not have approval rights over the film itself. Jackson never would have agreed to be associated with the film, absent an opportunity to confirm and ensure that it met his high standards. Anything less would irreparably damage his carefully curated and award-winning reputation as a film and television producer. To add insult to injury, defendants have not paid Jackson a dime in connection with their unauthorized use of Jackson's services and intellectual property in connection with this film. So let me kind of bring it back on myself here for a second. You guys have to let me know in the chat. This is what this is the equivalent of. You start working at a job, and pretty much when you start working at a job, you're signing some type of an employment agreement. Would you start working at the job without having signed any type of an employment agreement? That's essentially what 50 Cent did. He said, look it, I'm gonna give you guys, I'm acting your film. I know, man, we are squared away on the back end. Despite this guy having a series of fraudulent or what they say, not fraudulent, a series of scandals and bankruptcies. He's trusting this guy that he's going to square him away on the back end. Effectively, 50 Cent provided the services. Again, that's like you and I working at a job without signing any type of an employment agreement. We don't even know what we're supposed to get paid. This makes no sense. No sense, 50. And now you want to sue for intellectual property as well as some other things. I don't know, man. 50 way too smart for this. To make matters worse, defendants have not stopped at misappropriating Jackson's valuable intellectual property for the film alone. They are also using Jackson's IP in the film to promote their new streaming platform, Gen TV, a platform which directly competes with Jackson's own streaming channel, 50 Cent Action. So it seems like 50 Cent also got a streaming channel called 50 Cent Action. In other words, defendants plan not only to steal Jackson's reputation and goodwill amongst his millions of fans to boost their own film, but also to use that film to unfairly compete with Jackson's other business ventures. Obviously, Jackson never would have agreed to allow his IP to be used in such a manner. You got to be smarter, 50 Cent. This is really an indictment on 50 Cent, in my opinion. This guy has a number of scandals and bankruptcies, and you thought he was going to do right by you. Okay. Despite plaintiffs' repeated objections and demands to cease and desist, so it seems like 50 Cent sent a number of cease and desist letters to the defendant. The defendant continued to infringe and misappropriate 50 Cent's IP rights and intends to release the film in the coming weeks, if not days. Should the film be released publicly, Jackson faces irreparable harm to his valuable brand and reputation. This court must therefore enjoin the defendants from releasing the film and using Jackson's IP to promote the film in the Gen TV platform. We're going to skip the jurisdiction and venue. Man, we know enough about 50 Cent, so we're going to skip that as well. Let's get to the acts here. Jackson is one of the most parties. I want to skip that. I want to get to the defendant's bad actors. Okay, negotiations over the Skillhouse film. In or about 2022, 50 Cent entered into a discussion with Skillhouse Movie and Kavanaugh for Jackson to potentially act in and produce the film. The parties only got as far as negotiating a term sheet, but that term sheet was never finalized. Despite the drafts containing signature blocks for Jackson and G Unit, neither signed any version of the term sheet. Upon information and belief, Skillhouse Movie never signed the term sheet either. So they were negotiating, they had a term sheet. Neither party signed the term sheet. This is for the Skillhouse Movie. Let me know if you've seen the Skillhouse Movie. I never knew such thing existed. It was understood and expected that any agreement with Kavanaugh and Skillhouse Movie would be negotiated and memorialized in a long-form signed contract, and that the term sheet was just a term sheet, which would act as a placeholder pending a comprehensive agreement. To avoid unnecessary delay and based on a mistaken good faith belief in Kavanaugh's promise and reputation, Jackson filmed scenes to be used in the film once a final agreement was reached. So it seems like 50 Cent thought he was going to film it on the front end, and then once they kind of finalized the agreement, that was going to be essentially used in the film. It seems like Jackson, his son Sayer, we know we ain't talking about love 50 Cent. It seems like Jackson's son even filmed some scenes. That's crazy. He got the son involved in it. Jackson expected that Kavanaugh and Skillhouse Movie would continue to negotiate, memorialize, and finalize an agreement between the parties in a long-form signed contract. Jackson's trust in Kavanaugh was misplaced. You think a guy who had bankruptcies and had a number of scandals, and you think that the trust was misplaced? Man, come on, man. This is pathetic. And no final agreement was ever reached between the parties regarding the film. In fact, Jackson was never compensated for his participation in the film, either for his acting or his purported role in producing the film. That's crazy. But for 50 Cent to be so seasoned, yet to act in a film, not be paid, and then try to sue somebody on the back end because the negotiations broke down. That's crazy to me. The lack of a final agreement and failure to compensate Jackson should come as no surprise because, on information and belief, Kavanaugh failed to keep proper records and unilaterally modified the film budget to the tune of millions of dollars, making it virtually impossible for any back-end compensation to be awarded. The finished promotion of the film using Jackson's name, image, voice, and trademarks without authorization. The defendants have made Jackson the centerpiece of their promotional and marketing efforts for the film. I would have did the same thing. Not only is Jackson being used to promote the film, but on information and belief, Jackson is heavily featured in the film. A roughly 90-minute clip from the film is currently available for free on Gen TV streaming platform. So it seems like you can go watch the movie for free. The clips on screen credits predominantly labeled as a 50 Cent movie and produced by 50 Cent. The clip also lists Curtis 50 Cent Jackson as a cast member. The official trailer for the film prominently features Jackson, and the description under the video states, starring multi-talent icon Curtis 50 Cent Jackson. Again, it seems like this Kavanaugh guy is milking 50. The trailer even features distinctive bottles of champagne, Jackson champagne. Hey, at least 50 Cent getting some free promotional on the champagne. Press coverage of the film, which on information and belief is driven largely by the defendant's marketing efforts, associates Jackson's name and reputation so closely with the film, such that the film has been labeled a 50 Cent film. Again, he milking it. So it seems like Skillhouse Movie has 100,000 followers. Look at that. How far would you go for clout? Starring Bryce Hall, 50 Cent. Definitely got 50 Cent name on that joint. Despite defendants prominently advertising Jackson's purported role as a producer of the film, Jackson has had no creative control over input into the movie. So it seems like obviously Jackson is clearly not a producer of the film. Defendants are capitalizing on Jackson's reputation to launch the Gen TV streaming platform. Seems like 50 Cent got played in this one. Defendants are not only using Jackson's name, image, voice, and trademark to promote the film, but they are also using this IP to promote their nascent streaming platform GNTV. Indeed, defendants have used Jackson's IP in the film to market and launch GNTV streaming platform. Defendants' effort to associate Jackson and his IP with GNTV include sponsored articles. So it seems like, man, this guy clearly was trying to promote his GNTV streaming platform using 50 Cent. Based on public records, it appears that Kavanaugh and GNTV intended a business model. The intended business model is to have public figures and influencers both participate in the platform films and also to take on the work of marketing the film that would traditionally be handled by the platform itself. Most people do that. Indeed, a July 2024. Hey, let me know in the comments if you guys have seen this Skill House movie. This apparently is the name of the film Skill House, and it's on GNTV. I've never heard of the streaming platform, but it's featuring 50 Cent. So produced by Kavanaugh and 50 Cent. Let's kind of continue on here. We're almost finished. Based on the public records, it appears that Kavanaugh and GNTV attended business models to have, okay, we read that one already. Indeed, a July 2024 press release from GNTV stated Skill House marks the beginning of an ambitious project by GNTV to release 5 to 10 films annually. And that's a lot of films. Each headlined by top influencers. These films will be uniquely distributed through 2 distinct platforms: short-form episodic films released on social media by the influencers and traditional full-length features. So they're going to do essentially, short films for YouTube, and then your feature, your hour and a half films. Upon information to believe, the finished plan to release the film. It seems like obviously they're going to release this film any day now, according to 50 Cent's attorneys. GNTV, startup streaming platform, is a direct competitor to Jackson's own streaming platform. Now look it, man, I guess Tyler Perry has kind of worked with BET, but I don't think Tyler Perry has a streaming platform. So obviously Tyler Perry sells his movie, his I don't know, man. Yeah, he kind of sells his TV shows and movies to stream just platforms in general, whether it's BET. I think he has some stuff on Netflix, and he has some stuff on your cable providers. But I don't think Tyler Perry has a streaming platform, so it's a little different compared to that. Okay, GenTV is a direct competitor of Jackson's own streaming channel. I didn't know 50 Cent had a streaming platform. Jackson never would have agreed to compete with himself. What the fuck did you think was going to happen with the film? You thought he was going to put it out in a movie theater? This is what I'm saying, man. This kind of makes 50 Cent look bad, because 50 had to know that this was going on some type of streaming platform. 50 couldn't have thought that this was going to go out in the movie theaters. I'm pretty sure that they had to have that conversation at some point. So this, again, I think this, like I said, this makes 50 Cent look bad in my opinion. Before the filing of the complaint, Jackson repeatedly raised the issue with the defendant. For example, late last year, the publication Maxim published an online article entitled 50 Cent and Ryan Kavanaugh Take on Hollywood with an Influencer-Driven GenTV, falsely implying that Jackson was affiliated with and even had a leadership or ownership role on GenTV. That does kind of look a little suspect. 50 Cent and Ryan Kavanaugh Take on Hollywood with the Influencer-Driven GenTV. Yeah, that's a little suspect. I would agree with that. Hey, man, it's a dirty game, especially in Hollywood. A Jackson representative immediately reached out to Kavanaugh to ask him to facilitate a correction. Kavanaugh claimed that he told the publication that Jackson was an owner of the film, but the publication missed. Blame it on the publisher or the publication. That's how you do that. That's funny. Kavanaugh's explanation was dubious. The Maxim article is labeled as a partner article, meaning that it had paid for a piece and not genuine press coverage. Any content on Maxim.com, which includes the disclaimer, language partner. Okay, let's move on here. In response to Jackson's complaint, the title on the Maxim article was changed to remove reference to GenTV. 50 Cent and Ryan Kavanaugh Take on Hollywood with Skill House. Okay, that seems a little bit more accurate. Despite having raised concerns months ago, Jackson's name, image, and trademark still feature prominently across the GenTV platform. So it seemed like in this case, 50 Cent wanted stuff to be taken down, his names and trademark to be taken down from the GenTV platform. That's not the case. Okay, this is a GenTV platform here. Let's kind of blow this up. This is getting a little interesting. Skill House. So this is the name on Gen. I mean, again, it's still featuring 50. I mean, 50 Cent is still an actor. You can't get mad that he's I kind of want to see what it says. The 10 top influencers are kidnapped and forced into a deadly social media showdown where the stakes are life and death. As the world votes and watches each rounds, loser faces a mass killer known as the Triller Killer. In this ultimate popularity contest, only one will survive. Cloud is life. So it seems like that's what Skill House is about. Let me know if y'all have seen this in the comments. According to it, so this is just a couple days ago, email from Defendants Counsel. The film is scheduled to be released later on this year, in a couple months. Jackson and his counsel and representatives had multiple communications with Kavanaugh's counsel in the weeks before the scheduled release of the film. Despite Jackson's efforts to amicably resolve this dispute without judicial intervention, Defendants Counsel denied that they are. Hey, man, you dispute with yourself, 50. We cool. Oh, we don't got no bad blood. That's essentially what this is saying. Defendants Counsel denied that there's any dispute, even though he hasn't paid 50 cents. That's crazy. They also claim that Jackson has no approval rights over the film, despite it being marked as a 50-cent movie produced by 50. Even more concerning, Defendants Counsel had represented that defendants have been exploring the franchise potential for the film, including sequels, prequels, spin-offs, and remarks, which are currently in various stages of development, indicating that defendants will continue to infringe and misappropriate Jackson's IP for years to come, if not enjoying. Look, that's what I was saying earlier with the Ryan Coogler. And, let me kind of bring it back on myself. That's what I was saying earlier with the Ryan Coogler's film. When you have a film, that film is a copyright. And part of ownership in a copyright is you have the ownership in derivative works. That may be a sequel to the film. That may be a prequel to the film. That may be a TV show. You have all these things that you can do based on you owning that copyright to the film. It seems like in this case, 50 Cent's attorneys is saying, hey, this guy's going to continue to infringe our trademarks, our intellectual property, if you let this go on. Yeah, man, this makes 50 Cent look bad, because how do you act in a film thinking that things are going to be taken care of on the back end, even though this guy's telling you, or this guy has a series of scandals as well as bankruptcies? I don't know, man. I'm kind of upset over this one. Let's finish off here with the trademark infringement, the first cause of action. We'll only do the first cause of action, and then that's pretty much it. Plaintiff re-alleged and incorporate. Okay, whatever. Plaintiff Jackson is the owner of the 50 Cent marks. The 50 Cent marks have also acquired substantial goodwill and secondary meaning. Kavanaugh have made unauthorized use of the 50 Cent marks in commerce in connection with the sale, offering for sale of the film. Defendants, man, I'm not seeing any. He's not using 50 cents. He just say 50 Cent, which is, essentially the name of an actor. Let me go back to the other one. He's just saying 50 Cent. The plaintiff has not showed anything saying that, or showing that he's using illegally the 50 Cent's IP marks outside of, I guess, the name 50 Cent, which I guess is protected via a trademark, but it also doubles as the name of one of the actors, 50 Cent, that he's promoting based on him being in a film. Defendants unauthorized use in commerce of the 50 Cent marks, as less hearing, is likely to cause confusion or deceive consumers as to the affiliation, sponsorship, or endorsement of defendants' goods and services. I mean, look, I just disagree with that. Just because you're an actor and we're promoting you to be an actor in a film, which you are, that doesn't mean that you somehow have kind of more ownership in a film outside of being an actor. Unless restrained by this court, Kavanaugh will continue to make unauthorized use of the 50 Cent marks in commerce in connection with them. I disagree with that. I think paragraph 6 is going to be a hard sell. Defendants have committed to the foregoing acts of infringement with the full knowledge of rights in the 50 Cent marks and with the willful intent to cause confusion. Man, and that's pretty much it, man. So what do you guys think about this? I think 50 Cent is going to have a hard time with this case. Now, 50 Cent's attorneys had part 2 of the film, whatever the film is called, Skill House, and they had 50 Cent acting in it. Then they can, probably show that, hey, they're going to continue to infringe on these, on the IP of 50 Cent. But I don't even think they're infringing on the IP based on what we saw in this complaint. They're pretty much saying, hey, 50 Cent is an actor in a movie, and 50 Cent is an actor. Just because 50 Cent, the name, is also doubles as a trademark, that does not mean that, at least in my opinion, that they're infringing a trademark. I don't think they're using a 50 Cent name as a trademark, essentially using it as a brand. They're pretty much saying, hey, this movie has 50 Cent in it, which the movie does have 50 Cent in it. So again, let me know in the comments if you guys disagree with me. All in all, I think this underscores a point of make sure y'all business is right on the front end. Like I said at the beginning of this, that'll be pretty much like me and you going to our job or our employer and performing services without having an employment agreement. That's essentially what 50 Cent did. And then on the back end, when the employment, like, man, shit, you did the work, so we gonna use the work that you did, the scenes that you filmed in, and 50 Cent don't like that. Now, I did think that publication saying that it was 50 Cent and Kavanaugh's Gen TV, that kind of was misleading, which it seemed like they ultimately corrected. But again, Kavanaugh and Gen TV, like, hey, we don't got no dispute. We good over here, even though 50 Cent and his attorneys are saying, hey, we still got some business to work out. So, like I said, man, all in all, make sure y'all have y'all business right and buttoned up on the front end. If not, you're going to spend more money filing a lawsuit, paying attorneys, and kind of dealing with this. And again, hopefully you guys enjoy this one. Like I said, it's deeper than the game. This intellectual property is important for a number of reasons. One of those reasons, or two of those reasons, is to give you freedom as well as to give you control, which is what, again, this whole lawsuit that we just talked about kind of underscored the fact that, hey, 50 Cent doesn't have control. He talked about, hey, he said, I'm a producer, but I don't have control of it. He doesn't have control because he's not the owner of the copyright. So that's essentially what intellectual property gives you. It gives you control, and it gives you the freedom to be able to kind of make money at this stuff without having to go to a physical place. And yeah, that's pretty much it. So let me know if hopefully you guys enjoyed this one. We're at about 50 minutes, which is kind of perfect for me. I got the old Topo Chico. It was a good day today, even though the Pistons lost. Continue to protect that intellectual property. I do have the ebook to the extent that, again, we got the God IP, the ebook. That link is in the description. Go check out that. This is essentially a step-by-step course from you coming up with an ideal all the way up to you monetizing off that ideal. And I'm kind of interweaving stories from these Shark Tank or from these interviews that I did. Many of those interviews are from Shark Tank guests. So it's a pretty dope book. It's an ebook. And again, I think this is definitely something that will help you out in your, protecting the intellectual property and, coming up with an ideal and monetizing your IP. We talk about licensing in there. We talk about I talk about a lot of different things in there. So definitely go check out that ebook. That link is in the description. So again, hopefully you guys enjoyed this one. And I'll catch you guys next week. Let's go. Peace out.